We're in New Jersey. Actor Gary Busey is back in court via Zoom this morning. He's accused of inappropriately touching at least 3 women at the Monster-Mania convention in Cherry Hills, New Jersey, at the DoubleTree Hotel back in 2022. He touched the women, they say, during a photo shoot. He denies the allegations. Let's go back and listen into more of this hearing.
His hotel, not employees of Mr. Busey. In any event, Judge, my primary argument is that if a grand jury, why not give it? There was no difficulty. For a second, firstly, I know I think investigation kind of segues into this whole thing, because the failure of the police to actually reach out and question Ms. Higginbotham, who was a direct line of sight possible witness, that's an error that affects, in my estimation, the integrity of the grand jury presentation. There was no reason to do that, to not do that, to not question her, or at least for the prosecutor eventually not to put a sworn affidavit of hers, which creates a whole lot of doubt about whether Mr. Busey did anything wrong or not, whether it's inappropriate or not. As I agree with the court, that's a jury question, inappropriate, but we can assume, I believe fairly, that neither of these individuals would consider appropriate some type of sexual contact that they observed. I think that's beyond cavil that would be the case. So in the end, it's I believe under State versus Hogan and the duty of the prosecutor, again, I don't want to reiterate, the court's well aware of those announcements and declarations about the duty of a prosecutor. There was just no harm in giving the grand jury, and no extra time. They simply had to put into evidence these 2 affidavits, even if they didn't take the time to get statements. By the way, law enforcement didn't even take a written statement for Mr. Philpott, another alleged possible eyewitness. So for that reason, I think the faulty investigation, if you will, contributed to the eventual unfairness that occurred during the grand jury presentation. I understand what Your Honor is saying, and there's some trial issues here, but we're saying is the case should not go to trial because the grand jury was not given an accurate, full picture of the evidence in the possession of the state. I'm assuming my predecessor counsel, in sending these affidavits to the prosecutor's office, which the prosecutor's office has acknowledged receiving, I'm assuming it was sent in order to demonstrate that the evidence did not support a charge against Mr. Busey for these offenses.
So you're saying to the court that each of these affidavits, the entirety of these affidavits, should have been given to the jury?
At the very least.
That's what you're telling the court? At
the very least.
Okay, Mr. Carmi, I'll hear from you.
Thank you, Your Honor. Your Honor, the state's response to the motion of the defense is really twofold. First, that the information that counsel has discussed, the 2 affidavits, are, number one, not clearly exculpatory. Your Honor, I just point out, I'm sure the court has had an opportunity to review the state's brief, and I'd rely on that. Just a couple points from Hogan, which is the primary case that we look to with respect to motion to dismiss the indictment. Hogan court indicated with respect to exculpatory testimony that exculpatory testimony of one eyewitness is not clearly exculpatory if contradicted by the incriminating testimony of a number of other witnesses. So in this case, we have that situation where we have certain testimony that counsel suggested the state should have presented to the grand jury, which is flat out contradicted by at least 5 of the victims, and partly by the defendant himself in his own statement to police. This Hogan court also indicated that exculpatory evidence should be analyzed in the context of the nature and source of the evidence and the strength of the state's case. I think one of the reasons why the state did not present specifically the affidavit of Mr. Philpott is that Mr. Philpott is an employee of Mr. Busey. He was Mr. Busey's manager. There was an indication that he may have been present with Mr. Busey at some points during the convention, but that his statement, I'm not saying that, what he's saying in the affidavit is false, but there's certainly potential bias there in favor of Mr. Busey and having Mr. Philpott say, well, he didn't see anything. And that's part of the reason why the state's argument is that this testimony is not clearly exculpatory. This information is not clearly exculpatory. Is we have two apparent witnesses who are saying basically that they didn't see anything. That doesn't mean that it didn't happen. And that's information that's been contradicted by a number of witnesses in this case. So that's really the primary. The first point is that it's not clearly exculpatory evidence. The second point is, Your Honor, the state essentially did present this evidence to the grand jury. Even if the court were to find that what counsel's suggesting in these affidavits is clearly exculpatory, the essential substance of what's in the affidavits was presented, which is that the photographers who were present, or at least one, if not more photographers who were present, did not see the conduct occur, which is exactly what the state did.
All right, if you're just joining us, we're watching this Zoom hearing. Gary Busey, the actor, of course, is accused of inappropriately touching women at a convention during a photo shoot, and the defense is saying, you should throw this out, Your Honor, because during the grand jury proceedings, the prosecutor didn't include some affidavits of interviews with witnesses that said they didn't see any of this, including the photographer who was zooming in on Busey during this shoot, Cannon Kearney. Does the defense have any leg to stand on here? Basically saying that the grand jury process was flawed before, and they want the whole thing thrown out.
Well, based on the judge's posture, based on the questions that she's asking the counsel, I don't see that it's getting dismissed based on the arguments. It's clear that in her mind, she believes that the grand jury was informed that individuals, whether that be employees, whether they were specifically named, whether their specific titles and roles with Mr. Busey were informed to the grand jury, the grand jury was in fact informed that there were individuals who indicated to the police or to officers that they did not see anything. It appears that the argument for Mr. Busey is that these people should have been specifically named. Their specific testimony should have been stated. But it doesn't appear that the judge is hearing that argument, because in her mind, she's indicating that they were informed. It just wasn't to the extent that Mr. Busey or his counsel would have believed they should have been informed.
Yeah, at a trial, they can bring those people in if they want. That's likely where it's going to go. It's going to break. We'll monitor the Busey thing. We've got the jury returning in Washington. They are at work. And Montana, there's a live look inside the courtroom in Bozeman, Montana. We're waiting for day 2 of the return mail murder trial to begin. Stay with us.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Friday night, superstar guards face off as the Indiana Fever take on the Dallas Wings. Then the Los Angeles Sparks look for a win against the Seattle Storm. Coverage begins Friday night at 7. Find Ion wherever you watch. Ion, it's on.
Welcome back to Court TV Live. We're waiting for testimony to resume in Montana, and while we do, we're monitoring this hearing going on right now in New Jersey. Actor Gary Busey is back in a hearing via Zoom. He's accused of inappropriately touching at least 3 women at a convention back in 2022. The women say that he touched them during a photo shoot. He denies it. His defense wants all of this thrown out because they claim the prosecution failed to provide enough information for the grand jury to have a full sense of what happened. Let's go back into the hearing.
Okay. With that, the court makes the following finding. I have reviewed the moving parties' papers. I've also reviewed the state's briefs. I have also reviewed the exhibits as submitted by the defense. I find that the application to dismiss the indictment is denied for the following reasons. What's before the court is that on August 13th, 2022, the police responded to the DoubleTree Hotel located at 2349 Marlton Pike West, where the Monster-Mania event was being held. As reported to the police by 4 separate females, that the defendant, Gary Busey, had grabbed their buttocks. There were other allegations reported by other females against Mr. Busey. One of the females reported that, in addition, that the defendant had touched the outside of her vagina. The defense argues that the state failed to present what's the affidavits or certifications from a Heather Higginbotham and a William Philpott. Now, each of those individuals are identified as being part of the photo shoot. They were the photographers, it's my understanding as I read those exhibits. And looking at the law, under the New Jersey Constitution, no person shall be held to answer for a criminal offense unless on the presentment or indictment of a grand jury. As the New Jersey Supreme Court has explained, the grand jury operates by bringing to trial those who are probably guilty and declaring innocent of baseless charges. State v. Tucker, 473, and J. Super, 329, Appellate Division, 2022. Grand jurors serve a dual purpose: to determine if probable cause exists and to stand between the defendant and the power of the state, and to protect defendants from unfounded prosecutions. To fulfill its constitutional role of standing between citizens and the state, the grand jury is asked to determine whether a basis exists for subjecting the accused to a trial. That's State v. Hogan, 144 NJ at page 220. The role of the grand jury is to determine whether the state has established a prima facie case that a crime was committed and that the defendant was the individual who committed said crime. State v. Hogan, 144 NJ 216, 1996. In addition, the New Jersey Supreme Court has defined indictment to mean that a basis exists to believe the charge if the evidence is on hand is not explained or contradicted.
All right, bad news for Gary Busey there. The judge denying the defense motion to throw out the charges because of how the grand jury was informed before making the decision on the indictment of Gary Busey. Cannon Kearney, no surprise, this thing moves on to the next level. There's a plea deal on the table, probation. He appears to not want to go that route. And is it because of his reputation, the acting, why do you think, or may this get to that point where he does accept a plea deal?
Well, we have 4 different women, Ted, so in itself, it's not looking good for Mr. Busey. I mean, unless they literally can prove that these women, at some point came together prior to this monster event and went there to deem him a monster, it's gonna be hard to say that, this didn't happen in some form or fashion. As far as the plea deal, again, his career is on the line. If he accepts a plea deal, he did it. And so if he did it, Hollywood may not be accepting, most likely won't be accepting of an individual who would do these types of harms to women victims. So I would say he has no choice but to fight it if he cares about his career.
Yeah, unless he has a statement worded that he. Yeah, well, we'll have to see. Wait and see. The judge. This is not over for today. The judge is going to be reconvened at 2 p.m. They're going to continue working through this case with Gary Busey.